Yep. Gentlemen, I always hate to remove one of the 7 to go to 6. I understand I think it's better for you to have 6, but if neither one of you have objections, I'll leave all 7 out.
We want 6.
That's fine.
Are you doing it random?
Yeah.
I didn't know if number 7 was the one.
All right, Gary.
I'm getting a playback in what I just said.
Oh, because it's not muted.
A lot of that. Have a seat, folks. All right. I wasn't even watching the clock. How'd I do on that 10 to 15 minutes? Was it close? Yeah, just say yes, Judge. All right, so we're in final instructions if you're following along. We're in page 1, duties of judge and jury.
Your Honor, I'm sorry to interrupt, but
Yeah, go ahead.
a brief moment to have closing arguments.
I always do that. Yeah, I can make them short. Go ahead.
I don't feel it's right to waive, but I would have, but okay. Ladies and gentlemen, the jury, brief moment to give you some closing arguments, at least as to the position of the people's case. Thank you again for being attentive. This went quicker than what we thought. Every time we anticipate one way or another, we're always wrong either way. But in any event, at least it's simple from the standpoint that we had one witness. He had the benefit of the video. So again, as I said earlier on, you saw the case as Detective Belowski saw the case unfolding in front of him on January the 6th. Now, you're going to get an opportunity to hear from the judge in a moment, and the judge is going to instruct you on what the law is. And so it would be your duty to take the facts as you determine them to be with the backdrop of the law and make a decision. We talked earlier a couple of times because it's important. We talked about the prosecution's burden beyond a reasonable doubt. There was some definition as to that, which you heard. I asked you during the time of jury questioning, if I were to prove the case beyond a reasonable doubt, would anybody have any inability to return a verdict of guilty? And then again, during the opening statement, I reminded you that I accept the burden beyond a reasonable doubt, but I don't want to be held to a higher burden because that's high enough from a proof standpoint. And I hope again that when the judge instructs you as to what that burden is specifically, that you take that serious, because that is important to me on both sides. I want to do what I have to do. I want to meet the burden that I have to meet, but I don't want to do any more than that, and don't think it's right to do that. But in any event, where are we at? Here's the facts. Here's the facts, or here's at least as we saw this unfold. Sergeant Belowski, on surveillance, based upon information that he had received a couple of weeks ago, before this, I should say, by Officer Johnson. He was made aware that there was somebody driving around in the township with a vehicle that looks like a police vehicle, and that a known defendant, Paul Dupont, was associated with him and had been engaged with him on a couple of different occasions. Based on the fact that he saw that vehicle, he started his surveillance. His testimony was that prior to that time, he didn't know who the defendant was. He didn't know who St. Clair was from anybody at that moment. Had no reason to have any interest in him, but did have an interest in Mr. Dupont. Did the whole weaving in around, and ultimately ended up where both vehicles were facing each other 150 feet away. For some strange reason, Mr. Dupont gets out of his vehicle and starts to walk toward the police officer. Strange, normally it's the other way around. When somebody has outstanding warrants, they seem to want to evade the police. But in any event, for some unknown reason, because he wasn't here to testify, and it doesn't really matter, he took the course to direct himself to Detective Belowski and did that 150-foot walk of life. You understood and you saw where Detective Belowski had the benefit of the lean machine, confirmed that there were outstanding warrants. He testified that his duty, among other things, is to effectuate arrest if somebody has a warrant out for them. He confirmed that that was the case. He testified that it was his purpose when he saw Mr. Dupont coming to him to complete that arrest. He testified that it would have been a typical arrest under normal circumstances, happens all the time. And while he's a police officer, it'll happen again in the future. And the process is the same. You put somebody in cuffs, you pat that person down, you take an inventory of what that person has in whatever form it is, a bag, a briefcase, whatever, a suitcase, because it's his responsibility to keep that inventory. You search the defendant before you put him into your vehicle for safety purposes. You just don't know. And that would have been conducted in a short period of time and probably without incident. However, the world changed a little bit that evening because we have a defendant in this case who had nothing to do with the encounter between Sergeant Pawlowski and Mr. Dupont, decided that he was going to interject. He was going to put himself into this situation by pulling his car up 150 feet and coming into contact with Sergeant Pawlowski. You saw the tape, so I don't have to go over all this. So what we saw is that initially the confrontation, or whatever word you want to use, was between Sergeant Pawlowski and Mr. Dupont when he told him to turn around, come back, you're under arrest, on and on and on. He had no interest in the driver at that point, even when he pulled up. There was no direction given to the driver until Mr. Dupont went over and put the bag into the car. Sergeant Pawlowski came over, shined the light, told Mr. St. Clair, I have no issue with you, just don't touch that bag. He was under arrest. Confrontation starts. You heard the confrontation. You heard what was said between the two. And I questioned Sergeant Pawlowski at that time, well, why couldn't you just take St. Clair out of this and put him and take him back and do what you were supposed to do? His testimony was, for safety reasons, I need to be focused on the defendant. And St. Clair had told him, I have a gun. He's in his car. Looks like a police vehicle. Call it what you want. Whether that's okay or not okay, whatever you decide, that's not what he's being charged with today. But this guy is driving around in a vehicle that looks like 95% looks like a police vehicle. He's interjected himself into a scene, into an investigation, into an encounter for which he has no purpose and no interest of being there. I guess you have to ask yourself, what was his motivation? I can't climb into his head, but in any event, he starts to confront Sergeant Pawlowski after Sergeant Pawlowski had told him, I have, with the light, I have no interest in you, just don't touch the bag. He immediately accuses him of stalking, harassing, and let the games begin, all the nastiness back and forth. Now, you didn't see Sergeant Pawlowski elevate, get loud with him until this thing continued to progress. If you remember, if you work through this, I mean, he just wanted to make sure that this guy left the scene so that he could complete that which he had a duty to do. I asked him, with all of what was going on, did that interfere? Did that obstruct? Did that hinder you of doing your job as a police officer and taking care of, or at least doing your duty as a police officer? And his testimony was yes. And then he explained how all of the delay occurred. Again, we talked about what his duty was. His duty is to effectuate an arrest. We may like that, we may not like that, but when he swears to uphold the laws of the township, the state of Michigan, and the United States of America, he has an obligation to carry out that duty. And that's what he was trying to do. His testimony is that based upon all of the actions of the defendant, he believed that he was interfering, hindering, and preventing him from doing this. Now, there was some discussion by Mr. Jadala during the opening statement that there were conflicting messages. And the conflicting messages we tried to work through. And if you remember, I had indicated that what we're going to see is we're going to see Sergeant Pawlowski tell the defendant in this case, on numerous times, it's actually more than 30, but I said 20 to 30, whatever you want to call it, to leave the scene. Go. Get out of here. And the purpose for that is he wanted to be able to, again, effectuate the arrest, complete what it is he wanted to do and get the heck out of there. He's got other things to do than to argue on the street. I asked him if there was other directions. He said a few. He said, I remember, don't reach, don't touch for the, put your hands on the steering wheel. Don't make any aggressive moves, basically is what he's telling them. But by and large, all the direction given was the direction just to leave and get out of here. If Officer Detective Belowski wanted the confrontation with Mr. St. Clair, he wouldn't have told him to leave. The evidence at that point in time was in the belief and the impressions of Sergeant Belowski. He's the one that's in control of the scene. And what did we see happen? We see another officer arrive, but that took some time, if you remember. Sergeant Belowski was out there for quite lengthy period of time, at least when you're having a confrontation with somebody. Mr. St. Clair had plenty of opportunity to leave the scene. He was told to leave the scene. And then Officer Johnson shows up, pulls in. Sergeant Belowski directs Officer Johnson to move his vehicle. Give him the opportunity to get out of here. That's all that he wanted. When Mr. Belowski was being cross-examined by Mr. Jadala, the issue was raised that there was a conflict to that, if you remember. Well, what was the conflict? Well, you're sending mixed messages. You told them not to touch the bag and not to move, but you had told them not to leave. So if I'm listening to a police officer and I'm told not to touch, told him to leave. If I'm listening to the police officer tell me not to touch the bag, I'm not free to go. That could be his impression. And how can that be if he's also telling me to leave? Well, I didn't have a chance to get back to Mr. Belowski because I'm only entitled to have 2 opportunities during the questioning fired up. But I'm going to play you 1.5 minutes of the initial incident, and what you're going to see is you're going to see Officer Belowski reach in, take the bag, and instantly after he takes the bag, you will hear him for the first time say, "Now leave." Play it.
What you doing? Get stuff down, face on. Why you got warrants? Why am I being searched? Because you're getting searched because you got warrants. Hey man, I got no problem with you, but don't touch that bag because he was under arrest and me some. I'm not. I'll put your hands on your bag. Put your hands on your bag. Put your occupation. That's fucking big deal. And big bomb deal, Frank. So I come up and say hi. You're gonna make me a fucking deal. No, I don't. I am the supervisor. Sir, you're in a vehicle that looks like mighty like a lot of patrol car. You can't shine that in my face. Actually, I can. Do you have your driver's license on you, sir? I am the supervisor, fool. You got a gun on you? You got a gun on you? Give me your CPO. No, I'll show it to you, but I can't do shit. Don't reach. Put your hands on the steering wheel. Put your hands on your steering wheel. Do it now. You call the chief. This is ridiculous. Yeah, it is. I'm not doing that. No, he was under arrest. You can leave. You can leave.
As he testified, his purpose for going to the car was to retrieve the evidence that he believed he had a right to pick up and take. His words were exigent circumstances. That means that if the car took off, there would never be an opportunity to retrieve the evidence. So there are exceptions to maybe the more strict rules. That's what he testified to that he believed. But the interesting thing is that up until that moment, until he had possession of the evidence, he never told Mr. St. Clair to leave. Why not? He didn't want him to leave at that moment temporarily. He wanted the evidence. His purpose to getting engaged was to arrest Dupont, uncover the evidence, take him to jail, and go on and continue to do his job. But he was prevented to do so. After he took possession of that evidence, which was his purpose for getting involved in this anyway, then he tells him 25 times to move on. I asked him again, why is it that you can't conduct the business at hand now that you have the evidence? His testimony was, again, I can't turn on a guy who's acting like this. I won't even try to put a word to it. I'll let you put your own words to it, but whatever you want to call that, who's armed with a gun. He's a police officer. Somebody's obviously extremely agitated, maybe even a little unstable, who knows? But he's not going to turn his back on somebody like that. He also has to protect the defendant that he has. I'm talking about Mr. Dupont, who he has in custody. He can't allow harm to come to him. He has to remain somewhat close to the vehicle so he can watch what's going inside. And he testified he shined his light, and vast majority of the time was on his hip and trying to keep his eyes on what was happening inside of there. Why was he doing this? He's waiting for backup. Isn't that what we understand happens a lot? Police officers can't act, react, or participate sometimes unless they have backup. Officers on the way. He would have loved for St. Clair to leave, told him again and again and again. After a period of time, here comes Officer Johnson. Now, Officer Johnson is on the other side of the vehicle, if you remember. He asked him to come over here so that they can stay together. Again, for what? Safety reasons, for the police. Now, that's their procedures, not mine. I don't pretend to write procedures for the police, but that's what he testified to is what occurred. Again, he tells Officer Johnson to back up, to give him all the room in the world to move on. Does anybody believe that St. Clair had any interest in moving on? If you come to that conclusion, I don't know what evidence you can look at to come to that conclusion. He did everything possible, everything to obstruct, everything to prevent, everything to interfere, everything to hinder possible, screaming, cussing, threatening, calling him all kinds of things, calling him a stalker, a harasser, throwing the Constitution at him out the window. Is there any action at all, any indication at all that this guy wanted to leave the scene? No way. He wanted the moment. He wanted to engage. He wanted to bait. He wanted to entice. He found an opportunity to take this to a higher level. Now, when you're in the deliberation rooms, you have an opportunity to look at all of the facts, all the circumstances, and consider the arguments of the attorneys, but that's not fact. But when you do that, you don't leave your common sense at the door. Yes, you're to follow the law as charged by the court, but it doesn't require you to leave your common sense at the door and not apply this. And I'm just asking you to consider those things that I raised right now from a commonsensical standpoint, not some self-created, not some way of looking at something that fits a narrative by somebody who is in whatever state of mind he's in. But apply your common sense and ask yourself if this is something normal that would happen in a traditionally simple arrest situation on a public street anywhere, and on this particular night in Sumter Township. We don't have to do that. We can apply our common sense when we look at this. I contend to you, ladies and gentlemen, that the proof is overwhelming. If this is not interfering with the police officer when he's engaged in carrying out the duties that he agreed to undertake and uphold, I don't know what is. I don't know what else has to happen. But I do know that we ask a lot of our police officers. I do know that we have sometimes that officers are not acting in ways that we would necessarily think they should, but by and large, these are good men and women that put on the uniform and go out and protect us. And we ask much of them, and we ask very little sometimes of us. And what we do ask for is the protection of officer safety, the opportunity to do their job, and maybe just a little respect once in a while. Maybe just an understanding that they're doing something that maybe the rest of us are not willing to do. I contend that I've proven my case beyond a reasonable doubt, and when you deliberate, I ask you to return a verdict of guilty. Thank you.
Mr. Gisella.
Once again, thank you guys for all your patience. Thank you guys for your attention during this trial. Prosecutor wants you to believe that the officer's duty was interfered with. You've seen the video. You've seen the officer had the opportunity, without Mr. Sinclair interfering, of speaking to Paul. You saw him handcuff him. You saw the officer use Paul as a shield to get closer to my client's car. You saw the officer be able to reach in the vehicle and grab the evidence in order to charge Paul. Rather than him being an interference, my client's the reason why they were able to charge him. He just showed you real fast this little snippet that they played for you for his closing argument. And you heard in rapid command the officer give 4 different commands. Give me your license. Is that a gun? Do you have a gun? Don't reach. Put your hands on the steering wheel. You can leave. Boom, 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 boom. My client says, I want to call the supervisor. Not only do I feel that you harassed me and you followed me, you just reached in my vehicle without my consent. There's a constant conversation. There's a conversation between the officer and my client that's constantly occurring. You saw the video. He tells him, when I asked the officer, so when you told him not to reach in the bag, was he free to leave? Well, it's a matter of perception. I agree, it is a matter of perception. My client has a way different perception than what the police have. My client at this point feels that his rights were violated and he expresses it. Maybe he cursed, not illegal. Maybe he's being what we call an a-hole. That's not illegal. He has every right to respond to the police the way they did. You saw the different incidences throughout the testimony. They ask him to leave. My client wants to go give him the Constitution. He tells him to get out the car and pick it up. A few seconds later, you can leave. Boom, boom, rapid commands, inconsistent commands happening right after each other. And after he asks him to leave, they're still talking. They're still engaged in conversation. They're still talking to each other. After this incident happens, he's told to leave, but an officer's there. You say, well, maybe he was in his way. But he admits he did all. Ask the officer to move. Once that officer goes to move, there's still conversation between the detective and my client. He's telling him, you're selling weed out of your vehicle, accusing him of a crime. And my client's engaging, you're talking. By that time, a second officer appears. Now he's telling him to leave. Now there's 2 cars. When do you have the opportunity to leave if you're constantly in conversation and you're constantly being given inconsistent commands? There really is no opportunity. My client has the right to be as belligerent as he wants to, but he is not disobeying a command that cannot be followed. He is not interfering with the police when he's in his vehicle with 2 other officers at the scene. There was no interference. Now, you have to understand why I asked the officer, why do you keep calling this a fake or a look-alike car vehicle? They're upset. They don't like my client. They don't like how he thinks, how he talks to them, or what he's driving. They're reaching to charge him for something. You watched everything that happened here. The judge is going to explain to you all the elements of the case. And I agree with the prosecutor. Use your common sense. That's all I ask you to do is look at what he said, look at the activities here, and use your common sense. How can my client obey a command where he's being shouted at constantly different and miscommunicating ideas of what to do? How can he interfere when the whole reason for this arrest to occur was because my client stayed there? We just ask you to please use your common sense. Remember everything that was said by the detective, and we ask you to come back with the verdict of not guilty. Thank you.
Mr. Young.
Maybe belligerent? It's the understatement of the day, my friend. Maybe belligerent. He has a right to be belligerent? Maybe, I don't know. He might have a right to be belligerent. He may have a right to be upset with rapid direction, like, give me your driver's license so I can make an ID. Like, show me your right to carry a gun that you just told me about. Like, don't reach. Like, put your hands on the wheel. These were not directions given to Mr. Dupont because he had nothing in life to do but give him orders. It was for his own safety. What is he supposed to do out there? You've got this belligerent individual who's making all these accusations, causing problems, doesn't comply with any request. And when did he feel like he was not free to leave? When the bag was put into the car. When did that happen? That happened 20 seconds after he pulled up. Remember? Dupont goes and puts the bag in. Pawlowski comes over and shines the light, says, I have no problem with you, just don't touch the bag. Within a minute, I just played it. Within a minute and 20 seconds later, he had the bag out. That's not an issue. That's just somebody grabbing to try to make an issue out of something that doesn't happen. I'm going to say this again. The actions by St. Clair, if that doesn't give rise to a level of interfering, obstructing, hindering a police officer when a police officer is trying to do his or her duty, I don't know what is. I guess I'm getting too old for this job if that's what it comes down to. But here's the test at the end of the day, and then I'll sit down. The defendant is charged with interfering, obstructing, hindering, and opposing a Sumter Township police officer while making arrest. Number 2, or refusing to disperse from a location upon the command to do so by the officer, times 30. And defendant's conduct occurred while this officer was discharging his official duties. The criminal charge is based upon the Code of Ordinances of Sumter Township, Chapter 14:27, which prohibits such conduct. To establish a violation, you're going to hear this. I'm reading you what you're going to hear in a minute. To establish a violation of this ordinance, the prosecutor must prove the following elements beyond a reasonable doubt. 1, defendant did in violation of Sumter Township Ordinance, Chapter 14, Section 13-27, interfere, obstruct, hinder, or oppose, or fail to disperse from a location upon the command of a Sumter Township police officer when directed to do so, all while the officer was discharging his duties. That's all I've heard for the last 2 hours. Sorry, it's not in the charge. The defendant knew or had reason to know that Sergeant Pawlowski was a Sumter Township police officer and performing his duties as a Sumter Township police officer at the time of this incident. Here's the catch. If you find that the Township of Sumter prosecutor has proven each of those elements described above beyond a reasonable doubt, you must return the verdict of guilty. That's where we sit now. We didn't sit that way a couple hours ago, but that's where we sit now. I thank you for your time.
Thank you, gentlemen. All right, folks, I get to read to you. We're on page 1, final instructions under duties of judge and jury. Members of the jury, the evidence and the arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember that you have taken an oath to return a true verdict, true and just verdict, based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way to decide this case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that Mr. St. Clair is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that Mr. St. Clair is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies in this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I may have excluded evidence that was offered or stricken testimony that was heard. Do not consider these things in deciding the case. Make your decision only on the evidence that I let in and nothing else. You should use your own common sense and general knowledge in weighing and judging evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. I'm on page 3 now, folks, witness credibility. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have and not be influenced by a witness's disability, gender, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does a witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think a witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. On page 4 now. The defendant is charged with interfering, obstructing, hindering, or opposing a Sumter Township police officer while making an arrest, either directly or indirectly. Or 2, refusing to disperse from a location upon the command to do so by the officer. And 3, defendant's conduct occurred while the officer was discharging his official duties. This criminal charge is based upon the Code of Ordinances of Sumter Township, Chapter 14, Section 14-27, which prohibits such conduct. To establish a violation of this ordinance, the prosecutor must prove the following elements beyond a reasonable doubt. 1, defendant did, in violation of Sumter Township Ordinance Chapter 14, Section 13-27, interfere, obstruct, hinder, oppose, or fail to disperse from the location upon the command of a Sumter police officer when directed to do so, all while the officer was discharging his duties. Number 2, that the defendant knew or had reason to know that Sergeant Belewski was a Sumter Township police officer in performing his duties as a Sumter Township police officer at the time of the incident. If you find that the Township of Sumter prosecutor has proved each of the elements described above beyond a reasonable doubt, you must return a verdict of guilty. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about January 6, 2023, within Sumter Township, Wayne County. When you go to the jury room, you will be provided with a written copy of the final jury instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agree on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own and you must vote honestly and in good conscience. Possible penalties should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to the court officer. It is not proper for you to talk directly with the judge, the lawyers, or other people involved in the case. As you discuss this case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and full instructions. If you want to look at any or all of the reference documents or exhibits that have been admitted, just ask for them. When you go to the jury room, you will be given an electronic copy of the instructions. That's your tablet. You've just heard. As you discuss the case, you should think about all my instructions together as the law you are to follow. We have prepared a jury verdict form that will go in the deliberations room with you. I'm going to the section labeled Evidence Instructions. The prosecutor has introduced evidence. No, that's not it. Mine didn't get updated. With the deletions from that section? Yeah. So gentlemen, I don't think there's a need to read evidence, defendant statement as evidence, because I don't think we had defendant statement.
Right.
Or inconsistent statements used to impeach.
Right.
I think that leaves us with motive. Agreed?
Right.
Yeah. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. He only has to show that the defendant actually committed the crime and meant to do so.
Now I'm moving on to witness instructions. Yeah, that one didn't get updated either. So fellas, under that section. Yeah, it's all right. On that section, gentlemen, weighing conflicting evidence, number of witnesses, unnecessary. As is character evidence, agreed.
Agreed.
Page 2, you have heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. Mr. Young, are you satisfied with the instructions as given?
I am, Your Honor. One matter I'd like to approach Steve Bench on when you get a moment.
Sure. Satisfied with the instructions as written?
I am, Judge.
Come on up. All right, folks. Where is our clerk? Oh, I thought he fell asleep.
Officer Crowe is going to take you back in for final deliberations. Now, coats, personal property, if you want to leave it here, it's fine. The courtroom's always going to have a court officer in here, or the door will be locked, one of the two. If you have notes, you want to take them in, fine. If you didn't take any notes, just leave them here. Same with your tablets.
Or at least take one tablet because I have the jury.
Yeah, if you want to look at instructions, they're there. And once again, if you need anything, Officer Crowe is not going to leave the hallway right outside your door. So if you have any questions, just knock on the door and he'll find out what's going on. All right, people, we are in recess.
Thank you, Judge.
It's down the hall to the right.
Good catch, though, Joe.
Oh, yeah.
He's a little sensitive about the juror.
Are we being recorded?
Yeah,
We're going on the World Wide Web, brother.
yeah.
I mean, I'm sitting here talking.
Yeah, the whole world heard you.
I tried to do that.
Yeah, there is a mute